Good morning, everyone. Distinguished speakers, professors, and also all delegates and also participants. I please welcome you guys to the second day of the icLave 2025. Please give an applause to all of us. It is a pleasure to see you guys again in this beautiful morning after a very long productive day tomorrow and also a fun night, I hope so, on a gala dinner. And today we will continue our exchange of the idea discussion on the beautiful and also very interesting theme. And here with us is already come also our speakers, our professors, and also our moderator that will lead today's discussion. And after though, we also have the plenary session 2. There is 2 sessions in this auditorium, and then following by that is a panel session on the admin's room that I believe is already on your schedule in the website though, so please kindly check the website. And today, as we will continue our conference with the 2 plenary sessions, and then will be followed by the parallel session in the afternoon. For the plenary session 3, at these hours, on our 3rd plenary session, we will discuss about the disruption, outlook, and urgency of the corporate, commercial, and comparative law approaches for future development. And in this session, we are honored to have our distinguished speakers, our beloved professors, and also our moderator. So please allow me to the moderator that will lead our discussion in the first panel. Please join me welcoming our moderator for this morning and for this 3rd session. There will be Dr. Ari Wahyudi Hertanto, SHMH. Dr. Ari Wahyudi Hertanto, SHMH is a senior lecturer at the Faculty of Law, Universitas Indonesia, specializing in legal fundamentals. Earned all the degrees, bachelor's, master's, and doctor from Faculty of Law, Universitas Indonesia. Also active as an advocate trainer, and also has served in various academic and managerial roles at Faculty of Law, Universitas Indonesia. So without further ado, I welcome Dr. Ari Wahyudi, and please, the stage is yours.
Yeah, thank you for the opening. Today we are already come to this Prof. Yeti Komala Sereriwi and Mr. Jiong Lu. I invite you to come to the stage. So, before we begin, I would like to say good morning, distinguished guests, colleagues, and fellow participants. Welcome to these sessions on the disruptions outlook and the urgency of corporate, commercial, and comparative law approach for future development. And apologize for the inconvenience, for waiting a little bit delay for the sessions, because at the first place we would like to have the Dean to also come to join us, but at the very last minute we are being informed that he already another schedule, a very sudden schedule. So after that we going to be like having like another additional 15 minutes for the sessions, and then allow me to have a brief on what we are going today. Corporations, though small in number, play an outsized role in shaping both economic growth and governance structures. Their influence extends beyond market dynamics, touching questions in sustainability, accountability, and even democracy itself. Today, we will explore how corporate governance and commercial law are evolving in response to disruptions, whether technological, geopolitical, or regulatory, and how comparative perspectives from Indonesia and China can inform a more balanced, forward-looking legal framework. So today, we are honored to have two distinguished speakers with us. Prof. Yeti Komalasari Dewi, so probably for Fakultas Hukum Universitas Indonesia students very familiar with her. Okay, she is an expert in corporate law and governance from Universitas Indonesia, who will share her insights on recent development in Indonesia, including the amendments of the State-Owned Enterprises (BUMN) law. Please give her a round of applause first. And then, secondly, Mr. Zhong Liu, he just saying to me that he has his nickname, Mr. John, John Wick, partner at Anli Law Firm, who will provide a view from China, focusing on the evolving legal landscape for corporations, the challenges in implementation, and the broader implications for regional cooperation and sustainable growth. So without further ado, after a quite short discussions, I will invite Mr. Zhong Liu to present his presentations. It is like China has undergone significant corporate law reform in recent years, with a focus on modernizing its company structures and strengthening compliance. And then, in this case, Mr. Liu, probably could you outline the key features on these reforms, how Chinese companies are adapting to such issues as sustainability, digital transformation, and cross-border partnership. Please, you have this.
Thank you, Doctor. Selamat pagi semua. So that's the bahasa I know for now. It's my honor to be here. I'm very glad. It's my second time in Jakarta, also second time in UV. It's a quite nice place, and I had a very nice discussion with all the professors here. Today I'm going to talk about some company law, latest development of Chinese company laws. So may I have the remote controller? Next, okay, thank you. So next, so I'm from Anli Partner, which is a Chinese law firm. We have about 15 offices in China, in the world, mainly in China, about 12 offices, and we have over 700 members, lawyers. And next, I do a lot of arbitration cases. I'm also an arbitrator of commercial case. Many institutions, including Chinese institutions, SIAC, the Singapore one, and the IAC in Kuala Lumpur. And I also do a lot of company laws and export controls. So, next. There are 4 topics I plan to discuss with you, but I think due to the time limit, I will focus on the first 2, the corporate governance and the corporate compliance. And I will slightly touch upon dispute resolution in China so that you can have a general picture of what it is in China. So next, about corporate governance. So give you a brief picture, whole picture of Chinese laws about companies. In China, the company law is a separate law. We have civil code, which is promoted, coming to force in 2020. The civil code covers areas including company law, contract law, tort law, family law laws, and others. But company law is a separate law. And our legal system is more like a German or Japanese style. We learn it from them. And we also have a lot of, inheritance from the old Soviet Union system. So basically speaking, we are a civil law tradition, but also in nowadays we adopt or we learn a lot of from the English law system, especially the contract law. If you open our contract law or contract law chapter in the civil code, you will find a lot of similarities of Chinese contract law with English law system. Next. And there was an amendment to Chinese company law in 2023. There are major amendments, including like we have a stricter capital contribution, the responsibility mechanism. In China, capital contribution is a way to protect protect the company and protect the commercial activities related to company. So we put a lot of emphasis on the capital contribution from the shareholder. And second, we enhanced board accountability and information disclosure. Third, we also reflect or put a lot of compliance into the company law, such as digital economy, which is a huge issue in China, ESG, and global compliance demands. And I will go into details later about compliance issues. And also we have a clear rules on shareholder rights, fiduciary duties. That's another something we learned from the UK and the US, fiduciary duties, and how to protect minority shareholders. So altogether, company law operates alongside with civil code and security law and the foreign investment law to form a comprehensive business law regime to, how to say, safeguard the interests of the shareholder and the company. Next. So basically speaking, there are two types of companies, basically speaking, okay? The limited liability company, which we see, I can say maybe 95% of the, or even more, of the companies adopt this structure, limited liability. Or we have joint stock limited companies. So the company limited by shares, it's used by listed companies mainly. So joint stock company are mostly larger companies. It's more complicated with more shares and with larger capital contributions. Next. And the governance structure is quite common in the nowadays business world. We have shareholders meeting, we have board of directors, we have board of supervisors, and below that we have senior management. What is special about Chinese companies is the party organization. If anyone here knows what that is, make a guess? Party organization. Well, it's not a party at night. It's not drinking party, okay? It's the Communist Party. So within China, we all know that Communist Party plays a very important role in China, okay? So in the law, we say companies, if the company has 3 or more full party member, Communist Party member, the company has to establish its own party organization, meaning that there is a certain group of people, right, in the company, and it has to have activities like have a meeting once in a week, once in a month, and it may have some opinions or advices to the company operation, things like this. That's what's in the law, but in reality, things are a little bit different because many people, especially private companies, and especially the foreign companies in China, they do not want to have this kind of party organization in their companies. It sounds kind of weird, or they're scared. So in reality, we achieve kind of balance between them. So it's okay for some companies do not have this party organization. So the law is not strictly implemented in China. Yeah, I'm okay with that because I'm also a party member, but the party activities are not fun, so it's not really a lovely party activity. So that's different. Okay. Okay. Next. So let's talk about the capital system. Okay, reform. So the law says, the new law says, the amendment says, there is a 5-year statutory deadline for capital subscription, or injection, I should say. So if I set up a company today, and within 5 years, I need to pay up my capital contribution. I know in Indonesia, maybe before a company is fully established, you need to pay it in. But in China, we different. So you can pay within 5 years. And then before that, before 2023, you have like 99 years to pay in. So it's a long year. But we find out, we think it's not proper to give so much time for the shareholder to put in money into the company. So we can give them 5 years to do that. And the creditor has the right to accelerate and to ask the shareholder to pay the capital if the shareholder doesn't pay within 5 years, or the company doesn't have enough money to pay its debts. So let's say I start a company today with a capital of $1 million, okay, for example. But next year I have a debt. The company has a debt of $2 million, and next year I haven't paid in my capital. So the company doesn't have enough funds to pay its debt. By then, the company's credit can ask me to pay the capital early, so before the 5-year deadline, so it can have more protection to the creditor. And also, China allows to pay capital in various forms. For example, you can pay by intellectual property, land use right, equity claims, or even labor. Okay, I'm not sure whether that's the same case in Indonesia. You can pay in capital by other forms, but in China you can do so. Okay. Next. So I made a comparison. So based on my limited understanding of Indonesian law, okay, that's different. And it's also interesting for me to learn that the minimum capital requirement for a foreign invested company in Indonesia is something like 100,000 US dollars or more, right? So in China, at the very beginning, like 20 years ago, we also have similar minimum requirement for foreign invested company, but the requirement is quite low. For example, the threshold is maybe 10,000 US dollars. So it's a very insignificant or a minimum amount. But now I learned that in Indonesia, if you want to set up a company by foreigners, you need to pay in capital about, I'm not sure if that's correct, but maybe 100,000 more or less, right? US dollars. Well, it's quite new to me. So it's okay for big companies like construction companies or mining companies, but it's difficult, or it's not that business reasonable for companies or consulting companies or other companies. So it's quite interesting to know that. Next. And also we have these expanded rules for the shareholders to get more information from the company. Because it's mainly the purpose of this right to information is mainly to protect the minority shareholders. Because in China, the company is always run by the people who has majority shareholders, right? The majority shareholder can appoint general manager and a finance head the company, so actually it runs the company, but how to protect the rights of minority shareholders. So the minority shareholders can inspect the accounting books and other records of the company. And also in the joint stock company, if you have certain shares and over a certain period of time, you can also do that.
Excuse
Yes.
me, Pak Jong, you have like 3 more minutes to summarize everything.
Oh, 3 more minutes. This is
Thank
fine.
you.
Okay. Okay, good. And next, I will pick some quite next most important one. Okay, because I saw it was 20 minutes. Oh, okay. So we also have these fiduciary duties. So the shareholders can sue the board members or general managers if they do anything bad. Okay, but it's very difficult to do that because the court requires a lot of evidence and put a lot of burdens to the plaintiff to produce evidence. So it's actually it's quite difficult to do that. Next, audit committee is not very important because the board of supervisors, actually based on my observation, does not have a strong role in the company structure. Next. Well, pursuing the corporate veil is also possible in China under the Chinese law, but in reality it's quite difficult because the court always put a lot of burden on the plaintiff to rule, to assess whether there is indeed a mingle of assets or undercapitalization. Next. About corporate compliance. So let's go to next page. Yeah, SOE. I think we will talk about SOE a bit later because SOE is state-owned enterprise, which plays a very significant role in China's economy, and there are special rules about compliance to the SOE to prevent the company from doing anything bad or to taking the money to their own pockets. So there is special rule to SOE compliance, which means if you are dealing with a SOE in China, it will take longer time for them to make any decision and take any actions. Next page. And next page. Yeah, FIEs, foreign investor enterprise. I should say 20 years ago or 30 years ago, FIEs are huge in China. There are a lot of many SIEs, but within like the recent 10 years, because of Chinese companies are growing very fast, I see a trend of some FIEs leaving China, right? So but there are still many FIEs in China, and they need to comply with the local Chinese laws as well as foreign laws, for example, FCPA rules. Next. AML, anti-money laundering, is such a new thing in China, especially not in using to the bank, but in using to like other industries, like law firms, like real estate agencies. Nowadays, they also need to comply with AML rules. Next. Next. Data compliance is also, it's quite a hot topic these days because in last month's deal, the diamond jury, deal was fined by the Chinese government for not complying with the data compliance and for disclosing unwillingly some customer data to others. Next. Data compliance. So in the interest of time, and I will go to the final page if you can. Shall we move to the final page of my presentation?
Boleh tolong ke halaman terakhir untuk presentasinya?
Yeah. The final one, yes. because I think you may have a lot of questions, right? No, the final one, yeah. The one with my email address. So if you have any questions, you can email me about Chinese laws, and that's my WhatsApp. So thank you.
Thank you. Yeah. So due to the very limited time, but thank you for the presentation. It is something that we need to catch up everything in 15 to 20 minutes, but yeah. Now I will have Prof. Yeti to present her presentations, please, Prof.
Thank you, Mr. Chair, Dr. Ari, and my colleagues, Mr. John, and Honorable my fellow speaker in the fourth plenary, and also I think also my colleague here, in the auditorium. Again, a very good morning to all, and Assalamualaikum warahmatullahi wabarakatuh. Allow me with this 15 to 20 minutes to speed up my presentations. Okay, next. Next, until, okay, I will divide it into, not to worry, 5 sections, but okay, we can go fast. Yeah, next. All right, yeah. Okay, let me begin with this, with these slides, because I tend to remind us with, whether we like it or not, but our historical background on our regulatory reforms. So in Indonesia, when we talk about the business entities, basically we are divided into 2 major codes in the civil code and in the commercial code. As you see that. Next. Okay. Now, because Indonesia, as other civil law countries, in view of the private laws, we tend to divide it into 2. Yeah, in the civil private civil or private law matters and the commercial matters. We understand that commercial is basically a private matters, but because we have 2 codes from the very beginnings. So what is basically the differences between these 2 codes? So the difference is that in the civil code, the aspect is not for the what I call usually commercial characters or commercial characteristic. So what is being governed in a civil code or in a fiber code is basically all of the aspect that has no commercial characteristic, whereas the commercial code, based on its name, of course, it has to be commercial characteristics. That's why, for examples, when we talk about the agreement to a sale and purchase agreement, it is governed in our private, the civil code. But when this purchase and sales agreement made by the business actors, it does not only apply the civil code, but it also apply the commercial code, as long as the commercial code has the regulations on that sale and purchase agreement, for example. Okay, next. Okay, now, based on that, when we talk about the forms of the legal forms of the what it is called as a organizations, entities, institution, association. So basically, if 2 or more persons gather together, they have the let me stand up. Sorry. Okay, so this one. So basically, every 2 or more person, if we gather together, they have the same interest, same willingness, or preferences, same goal, and they would like to cooperate. So based on that, usually then we ask of their aims or purpose. yeah, of getting together or involving together. Now, if the purpose is not for the commercial, yeah, activities, so we provide with this kind of legal forms. So whether we would like to have the to give the association as a legal personality status or not. So in Indonesia, if you are going to establish a corporate organizations or a associations that has a legal personality, you may opt to have a foundations, yeah, or staking. In US, it goes to trust, but charitable trust, yeah. And you can also choose a association or Vereniging, again association with the legal personality status, yeah. But there is also a non-legal personality status. So as a association or persons, yeah, and it was governed in Indonesian mass organization law, undang-undang organisasi massa, yeah. So we can have a two or more persons, yeah, get together, yeah, and then you don't opt for the legal personality status. Okay. And then the other, again, this is our sorry. So again, our focus on the commercial aspect. Yeah. So what is the Indonesian limited liability company? Is basically, yeah, the one, yeah, business entities that has a legal personality status. So only two business entities that has a legal personality status in Indonesia. Yeah, it is Indonesia limited liability company or Indonesia PT and cooperatives. Yeah, kooperasi. And those who are not having a legal personality status is again sole proprietorship in Manzak, sole trader, and partnerships. We have different types of partnerships. We have a civil partnership, we have a general partnership, we have also a limited partnerships. Yeah, I don't think that in our fellow, for example, in United States, we have a civil partnerships. Yeah, because civil partnerships is basically a matchcap. Yeah. It is different with the general partnership. In Indonesia, general partnership is basically a firma. Okay, next. Okay. Now, okay, this is just a historical background. So basically, this is civil code, commercial code here. Yeah, some of the commercial code and the civil, most of the civil code is still applied. Yeah, up to date. Yeah, and most of the commercial code, yeah, are still applied. Yeah. Okay, but some of them has been revoked. Yeah, now this is, yeah, the one that I should mention to you, that after this then we have a law and regulations, yeah, established after Indonesian independence. So it goes like 90s, 80s, yeah, 90s, 70s and 80s. So for example, law on mandatory registration to business entities. So at that moment, next, yeah, at the moment, no, still that slide, sorry. I think before that, move one slide. Oh, yeah, okay. So at that time, every business entity has to be registered, yeah, under the Ministry of Trade, yeah, and then all of the later on in 1997, all of the business entities and up to now, yeah, have to have a company documents. Yeah, so this is two mandatory, at least, yeah, important regulations on company or limited liability company. Yeah, but of course there is another, yeah, fundamental or important regulations with respect to the company, the Indonesian company or LLC. That is the one that governing the issue of registrations, yeah, licensings, yeah, and then the law that governing the business the business field, yeah, of the company. It has to be also important for the LLC, yeah, Indonesian LLC. Okay, next. Okay, I think, yeah, we can move it. Yeah, next. Oh, sorry, please, because you already mentioned about the, yeah, state-owned enterprise. Yeah. Okay. So we now have the new state-owned enterprise. Yeah. The third amendment. Yeah. So the first amendment, basically the law number 19/2003, and then the third amendment is actually the law number 1/2025. Yeah. Okay, and then again, still law number 1, 2025. Yeah, whereas there's only two types of state-owned enterprise. One, yeah, is what we call as the, yeah, basically limited liability company, yeah, okay, because it is stated in the law that the PT Persero as Indonesia state-owned enterprise in the form, yeah, of the private limited liability company, and it is also governed. It was emphasizes in the new law. It was governed by the Indonesia Limited Liability Company Act, yeah. So basically, it is a private, yeah, and the other one is what we call as a state-owned enterprise public, yeah, a company or perum, yeah. So the company does not issue the shares. So the very fundamental difference is that, yeah, the government or the state, when they establish the LLC, they issue the shares as a private, yeah, company. But then when perum, they does not issue the shares. Okay, next. Okay, again, next, yeah, this is okay. Yeah. Okay, now, yeah, this is just to show you, yeah, when we saw that, oh, Indonesian company law has been amended. Basically, it's only amended just one, yeah, chapter, yeah, because at the moment, yeah, Indonesia allowing one private, yeah, individual to establish a company, because previously the definition of the company is established by 2 persons or more, so it has to be an agreement, yeah. Even though I should say, since Indonesia first ever, yeah, modern or yeah, separate company law in number 1, 1995, yeah, we do have the exceptions of allowing one person to establish a PT. This is for state-owned enterprise. Yeah, and then when we revise the company law in 2007, yeah, now law number 40, yeah, we add, yeah, another exceptions. Yeah, this is for enterprises or business entities that dealing with capital market. Yeah, so we have 2 exceptions basically. Yeah, to establish a PT with only one individual, yeah, persons. And now in job creation law, yeah, to strengthen, yeah, the positions of the micro, small, yeah, medium enterprise. So the government allowing just one individual to establish the PT. So we have like what I call it single member limited liability company or one man company, ya, PT perseorangan in bahasa, ya. Yang satu lagi PT persekutuan in bahasa, ya. Okay, next. This is the, you can see, this is the definitions based on that. Even the government regulations, we enacted one government regulations, as a consequence of having this, new definitions on the PT, A. So we have like company established by 2 person or more. It is a ordinary, limited liability company. And an individual, company established by 1 person. I was, Professor Veronica, I was, revising, the law itself, because basically the government would like to say it is a PT established by 1 person. So the emphasis is to the number, But in bahasa they use the word used is perorangan. If it is perorangan, the emphasis is orang, is man, It does not really tell you how many person. So there is a wrong diction, a wrong, terms used, in this company, or in this in the new company law, Next. Okay, this is basically, so you have these types of, companies in Indonesia at the moment, So this, my left side is basically the ordinary, company, that side is state-owned enterprise. So basically the same, Now we have, under again, a company act, we have a private, tertutup, we have a public, But in our law, the public itself is, divided into the listed company and the just public company, There is a company that has minimum 300 shareholders and 3 billion Indonesia issued share, issued capital, And then the private, again, we have just ordinary LLC, yeah, and the other one is a single member limited liability company. Okay? Yeah, next. Okay, again, so we have again three company organ, company bodies. I think this is similar. General meeting of shareholders. Now, general meeting shareholder is not the highest. It is not the highest position in the company. It is a company organ that has a power, that is not granted to the directors. Board of directors is having the power to manage and representing the company, and does not have the power to advising or supervising the company, because this is the power of board of commissaries. So basically what we call as the general meeting shareholders is having the power that is decided under the company law and the article of association of the company, or sometimes we call it as a that the general meeting of shareholders having a residual power conferred in or granted in the company law, right? So in terms of boards, John, we have two types board, So from the very beginning, we divided the board. Sometimes when we call the board system, we have one-tier board and two-tier board. So under Indonesian company law, we have two-tier board, because from the very beginning, we divided the power for managing and the power of supervising. In one-tier board, you do have the power of managing and also the power of supervising in one board. Okay, next. This is two-tier structures. Now, we once have the issue of independent directors. So basically, the independent directors is the directors that supervise other directors. This was applied by the financial authority, financial services authority. But then it is in 2018. But then it was revoked because of many criticism. Why? When you put the independent directors supervising other directors, basically you are violating the company law, because the one that has to supervise the directors is commissaries. That's why then it was repealed. Now we don't have the independent directors, but we have the independent commissaries or supervisors. Next. Okay, this one, so we have a commissaries, delegated commissaries, we have independent commissaries, and for those who are applying the Sharia or the Islamic transactions, they also have a board of Sharia supervisory. Next. Now, this is the capital, because John, you just now tell about the capital. Okay. So basically we have, under Indonesian company law, we divided into three types of statutory capital. We have authorized capital, previously, issued capital and paid-up capital. Now, we don't have the number of exact, statutory capital or authorized capital, because then the law said it was decided by the incorporators or the founder of the PT. And it usually, previously it was governed by government regulation in 2018, and it was adopted by the job creation law. So it was decided by the incorporators. But the remaining, so this is article 22 or 23. So but there is 2 or 3 paragraphs. But the ratio, the shares ratio still exists, still prevail. So whatever the amount of the authorized capital decided by the incorporators, the ratio, the shares ratio still exists. So 25% of the authorized capital must be issued and paid up. Okay, in the when you establish the company, when you are going to have to be granted the legal personality status. Okay. And then in terms of types of capital, okay, not only money, in Indonesia,
Yes,
but you can also, how many?
3 minutes.
Okay, so we have not only money but also in kind. So tangible and intangible, yeah, property can be, yeah, can become a capital, yeah, of the company, as long as it has to be appraised, yeah, by the appraisal company. Okay, next. Okay, berapa lagi? Coba next. Masih B tuh. Okay, we do also recognize the fiduciary duty. Yeah, we do also have a paying the corporate bills. Yeah, so in Article C for the shareholders liability. Next, we do also recognize the business judgment rule. Yeah, for the, yeah, board of directors and commissaries. This is also, yeah, influenced by the common law system, particularly of course US, because when we drafting, yeah, our law on a company law, it was, yeah, helped, yeah, assisted by scholars, yeah, from the US, yeah. And then next, okay, now this is the issue of liability. So the liability on the board of directors, board of commissaries is not only in the civil, yeah, liability, but also in criminal liability. Okay, okay, next. Now, this is the contemporary issue, yeah, of the company law. So we have corporate social responsibility under our law, yeah. We the other now, the development is now, yeah, we also look at the environmental, social, and governance, yeah, ESG, yeah. It is also, yeah, influence, yeah. Not this is particularly for the public, yeah, for the public company, but for the private company it also, yeah, influence, yeah. And then we should also look at the business and human rights issue, yeah, because we already already have a task force for business and human rights, and also, yeah, we are, yeah, the National Committee on Good Governance, yeah. Now we have like shareholders stewardship, yeah. Okay, next. Okay, this is the contemporary of the new penal code, yeah, will be, yeah, enacted 1 January 2026, yeah. So what is, yeah, becoming challenges for the company law, yeah, not only scholars but also academia, but also a business actor, is that this one, yeah. So under the new penal code, yeah, the corporations is defined, yeah, as very broad, as it includes not only legal personality, yeah, legal entity, but also non-legal entity, yeah. And we now having a very intense, yeah, I was involved in from the department by Prof. Topo, Prof. Heftis to discuss about sanctions or penalties, yeah, that is being incurred, yeah, for the company, yeah, for the company, because, yeah, how we sanctions company with what we call as in bahasa Indonesia itu perwalian, ukuratel, ya. You put, ya, persons, ya, is not capable, become, ya, I don't know, but this is for legal person, ya. And then how you, if you are going to take over, ya, or pengambil alihan, ya, you take over the shares, kan, or you take over the property. How you take over, I don't know, the vesicles of the legal person. So there is issue when applying, yeah, sanctions that is, you know, being put to the natural person, to the legal persons. This is also one of the challenges, yeah. Okay, the other is the beneficial owners, yeah. Beneficial owners, anti-money laundering, also challenges, yeah, for our business society. Next, okay. Okay, this is, yeah, okay. Solution,
yeah.
Okay, commercial arbitration, we pass, yeah, and we're going to yeah. So basically, because John say, okay, this is commercial arbitration. Okay, one of the dispute resolutions, not only litigation but also commercials, yeah. And I think I have to end with my conclusion dong, remark dulu. Conclusionnya, please.
Conclusions,
Just
ya, halaman
please,
kesimpulannya, boleh?
Yeah, yeah, that's a closing remark. I'm not concluding remark, yeah. Not concluding remark because I'm not concluding, yeah, just closing. Now, we already know that Indonesia have, yeah, shaped its company law, yeah, okay, from many aspects, and the governments improve, yeah, the ease of doing business, yeah, trying to streamline the regulatory hardship and simplifying regulation. It is okay, it is good, yeah, but the issue is the method. then the approach, yeah, sometimes is proven, yeah, deficient, yeah, or too hard, yeah, too rush, yeah, because then it creating another problem, yeah, and now the government also trying to have a new legislatures, yeah, to replace outdated one, and one of the one that bill on the aspect of commercial law is the bill of business entities, and also the issue of the bill, and also already been I think signed, is the bill the law on state-owned enterprise. Yeah. So with this, again, we appreciate, yeah, the development, but also we would like to have a more transparent, more care, yeah, more transparent public participation on all of this development of the new law and regulations, particularly for the commercial sector in Indonesia. Thank you. With that, yeah, I'm sorry, and giving back the chair to you.
So let's give a round of applause for both center. Yeah, Prof. Yeti is a very good person to make all the audience having an adrenaline rush. But somehow, okay, without further ado, I'm inviting the floor, yes, if there's any questions, okay, probably from this side first, the gentleman over here, and then you have one. Okay, since the time is very limited, yeah, it is like 15 minutes from now. So, okay, what is your questions? And then please state your names and your institution first. Thank you.
Thank you for giving me the opportunity to ask the question. First of all, my name is George Matthew. I'm an international trade lawyer and also PhD candidate on trade and environment in Universitas Indonesia. So my question goes to Mr. John, and of course it relates to export control law, because again, as we can see, China has a really great arrangement concerning the reasonable period of time when it comes to export restriction. Well, I can assure you that it's unlike Indonesia, where we keep banning our export, and we got currently alleged by India and EU on various trade remedies issue. And my question is, how does this law actually operates in practice? Because as we see that China is currently alleged by exporting dumb products, or alleged with anti-dumping duties from various countries, but at the same time, they also apply an export control where they can somehow restrict the export of the goods. So in one side, like somehow they still sell the goods below the normal value of China, of course, regardless it is normal market economy or not. Second, I mean the export controls still run effectively. So thank you, Mr. John, and I hope the best answer. Thank you.
Okay, perhaps I'm going to the second question over there, and then after that, yeah, we can answer. Okay, please state your names, institutions.
Yes, okay. Good morning. My name is Justin from Legal Center for International Trade and Investment from Faculty of Law, Universitas Indonesia. My question goes out to Mr. John as well. China recently released their new arbitration law. Could you highlight the new features under the law and how it would help both Chinese and overseas businesses in resolving disputes through commercial arbitration? Thank you.
Okay, since all questions being answered to Pak John.
Thank you.
Okay,
Thank you
please.
both for raising these two wonderful questions, because my focus is really on export control and arbitration. Export control is really a very hot topic in China right now, and especially with professor from the US, I know it's kind of tricky, because you need to understand, we also need to understand the reason behind these export control rules. China has put a lot of emphasis on very tight control on rare earths, right? And because the reason behind this is we do not want to control anything, right? We just want to do business and make money. That's the basic mindset of Chinese people and the government. But the U.S. government wants to maintain its leading position, right, in the world technology, in the everything, right, finance, technology, and military. So actually, it bans export to China, like software, like semiconductor chips, and like Boeing components. So to kind of retaliate or fight back, we have to take those actions. But let's say just miraculously, the U.S. just released its export control rules right now tomorrow. China will do the same. So it's kind of tit for tat, you know. So I will talk more about this in the coming weeks, and I've written articles on this, so I will send you later. Okay, says export control. And for the arbitration, yes, for the past few weeks, we are talking about this new arbitration law in China. And this new law has been in discussion for many years, maybe 20 years or 30 years. And this version of arbitration is kind of negotiation among different parties, because there are different versions last year or the year before. And at the beginning, the draft version of arbitration law is not welcomed by legal profession, the professors, because the government want to have more control of arbitration. They want to control arbitration and treat arbitration just as court system. But luckily, we fight back. The legal profession and professors all fight back. And now the version you see has come out, right? Is a compromise between the government and the legal profession. And the features including like we acknowledge officially about the arbitration seat. So it means that if we do an arbitration before SHIAC, before the one in Shanghai, before the arbitration, Shanghai International Arbitration Center, both parties can agree the seat to be in Singapore or Indonesia, which means Indonesia procedure law can be applied to the arbitration procedure, which is quite, useful to international arbitration. And another feature is the ad hoc arbitration. So before, we do not allow any ad hoc arbitration in China, but with this new law, we allow some arbitration done by ad hoc way, but with limitations, with certain conditions. That's the major two features of this new law. So, yeah, that's all.
Okay. Any further questions on that? Probably, no? Okay. Any questions? Okay, first, and then... Okay, please.
Good morning, everyone. Good morning, Prof. Yeti. I'm Clarissa from University of Surabaya. My question is addressed to Prof. Yeti. Professor, what is your view on the changes in the state financial status of state-owned enterprises, or in Indonesia we call it BUMN, based on the latest change in the law? Because there have different views or opinion on this matter from both administrative and commercial law perspective. Is it justified to immediately separate the financial status of state-owned enterprises from state finances upon their acquisition as BUMN, BUMN capital, or should this change only arise when the BUMN undertakes some activities? Thank you, Professor.
Thank you, Mbak siapa? Mbak Karisa from Universitas Surabaya. I was there yesterday. Okay, that's why I think when we talk about state-owned enterprise, you look at the very previous law, the types of state enterprise is different. Previously we have three types: Perjan, perusahaan jawatan, we have Perum, and we have PT Pesero. Yeah. So those three types have different characteristics. And then we have the new law, law number 19/2003. It was only two types, yeah, Perum, yeah, and then PT Pesero. When you look, yeah, in the elucidation of the law itself on the 2003, it is stated, yeah, expressly that this type of business entity of PT Pesero is governed by Statblad 18 berapa itu? Basically it is governed by Indonesia Commercial Code. Now, Indonesia Commercial Code is a private. Yeah? So from when we talk about PT Pesero, from the very beginning, our founding fathers, yeah, is treated this as a private entities. So it is, if you talk about capital, similar as the shareholders, the capital is separate. Yeah, so capital, yeah, from the shareholders, yeah, and this is the source is the government, is when you already establish a PT Pesero, basically it is not again a state money. It becoming the money, the capital of the PT Pesero. So the government, the state, becoming a shareholders. The government will entitled to have dividend as a shareholders, yeah, lainnya, and as a shareholders. Now, the Perum is different. The Perum, because the government does not issue, yeah, the shares. But again, the Perum is a legal entity. It has a legal personality status. So again, the ownerships of the government is different with yeah, the ownerships of, yeah, the entities, because we have this theory of separate legal entity. It is not only in commercial law, it is not only in corporate law, but it is also, yeah, I think recognized by the administrative law as well. Yeah, for example, our scholars, yeah, Professor Prof. Arifin, the late Arifin Sumana stated, right? So basically, the capital of state-owned enterprise is not a capital of the government, of the state. That is why, yeah, the government established business entities, yeah, to find other resources of funding, yeah, to becoming a state budget, not only from the tax, but from the business entities. So it has to be clear, yeah, the distinction between the capital of these business entities owned by the state and the capital from the state itself, yeah. So I think the third amendment trying to put on the right track, but I don't know, again, yeah, in the fourth amendment, it becoming again, yeah, I think we go back to the, we went back to the other, yeah. So we just look, yeah, for the future, but for our, at least some of the corporate law, not only academia, but also practitioners will say that because this is benchmark, yeah, in other jurisdictions, yeah. So we have separation between, yeah, the business entities that has a legal personal status, and also, yeah, the state itself as a, yeah, public legal persons. That's it. Thank you.
Thank you. And then for the last resort, I would like to ask for both presenters today, before I'm closing this event, these discussions. It is about disputes and criminal stuff, yeah. I believe that Indonesia just enacted the new criminal code and then going to be fully running on the 1st January 2026. You were saying that you have like your concern about how they define terms of corporations or business entity in Indonesia. So the questions for both of the presenter, is there any, you know, like concern for this entity both in China and Indonesia about having the legal issue on criminal matters, and then secondly about commercial disputes. according to you, which one is best? Whether we are going to settle it amicably, or we or go to the court, or what is it? Okay, in your opinion. So only two questions, please. First, I come to Pak John.
Thank you. In the criminal law of China, we also have some chapters related to companies. So if you, especially state-owned companies, so the criminal law protects the state-owned companies, state assets a lot. So if the manager in the SOE does something bad and take money into his own pocket, there will be crimes, very serious crimes. But if a private company, right, as a manager takes money into his pocket, it's very minor crime, or even the police doesn't care too much about this. Okay, that's different. Second one, commercial disputes, court versus arbitration. I'm an arbitrator, so I always prefer arbitration, right? The court has, but every institution has its own problem, right? The arbitration, you know, there are too many arbitration institutions in China. We have over 280 arbitration bodies, just too many. I don't want that many. I should say we just want 10 is enough, okay? But it's impossible. And second, arbitration in China is getting slower because we have more and more cases in China before arbitration. But the court is much slower. Yesterday I talked with my colleague from Australia, and surprised to know that there's a fast track in Australia working quite well. But in China, it's very difficult, or it's not easy to file a case and really move forward the case. Yeah.
Okay, thank you.
I think I will begin with the second question first, yeah, because this is a commercial arbitration. So let us remember, yeah, that why the arbitration is set up from the very beginning. It was set up because, yeah, people know the commercial activities. Then merchants tends to settle by their own way. And we remember that commercial arbitrations is developed because, as you say, business persons would like to make money. Yeah? So they don't want to have a dispute. So the primary aspects, yeah, of the arbitration is that people would like, even though basically business people does not want to have a dispute, or if they have to have a dispute, they have to settle it, yeah, faster. Yeah, of course, with the legal certainty, yeah, that has to be acquired in that process. That's why arbitration does not have a review mechanism, right? Yeah, mostly, yeah. So they only have a annulment process. That's why, yeah, I'm again, not for me to say it is arbitrations or litigation. So both of them has their own characteristics, and the business persons have the preference, yeah, to opt whether they want to have a litigations or arbitrations, as long as sometimes they have a strategy to do it, yeah, and they have to respect the choice that they have to make. If they already choose the arbitrations, go it, yeah, after finish, and then if you do have the award, and exercise the award, yeah, do not go beyond, yeah, another path. Yeah, that is not good. Yeah, okay. Now the first one is.
The first one about your concern on the Indonesian.
Yeah. This is our concern. Yeah. So at the moment, yeah, when we don't have the new penal code or criminal codes, yeah, what happened in the state-owned enterprise atmosphere? Every director is reluctant to have a business judgment, a business decision. Why? Because if they, yeah, took these decisions, yeah, to basically to find to profiting, yeah, the company for company to profit, and then it's not profit, yeah, it's not profit, then it is corruptions under Indonesian law, yeah, even though there is no, yeah, corruption, real corruptions. Okay, so this is, yeah, in the state-owned enterprise, and also it is happened to the private companies. Every directors, yeah, they don't want to take, yeah, decisions because again you can criminalize them. Yeah. So for me, it is okay if you have factors, yeah, that they violating certain rules, yeah, certain provisions on penal codes. Yes, you go, yeah, you penal that, but not for the person, not for the directors that is not have mens rea or an intention to fraud and so on, yeah, because the main obligations of the directors of the companies is to make decisions. That's why we have a business judgment rule. That's why the decision made by the directors is protected under the law. Otherwise, you don't have you don't want to make a decisions. And now with this penal code, you can imagine, yeah, you can imagine, yeah, because I have to be in the middle, yeah, I'm not, yeah, 10 for the I also have to speak for the government for the upheld the provisions of the if the person violating the law, but I also have to speak for, yeah, on behalf of the business person, yeah, we have to, yeah, to look carefully, yeah, with this issue, and I'm afraid we cannot generalize all of the violations made within the company as a criminal, violations. That's it. Thank you.
Thank you for the questions. It is very fabulous. And then that final questions actually close everything up. Thank you, Professor Yeti and Mr. Liu, for your rich and thought-provoking insights from today's discussions. It is clear that Indonesia and China are navigating challenges, yeah, and then we both believe that these events provide us with insight materials, yeah, and then we can move on the next phase of cooperation and more than that. And then on behalf of the organizing committee, I would like to thank our speakers and all participants today for joining us in these engaging sessions. We hope today's dialogue inspires further collaborations between our institutions and countries. And I'm going to return this to the Master of Ceremony, please.
Thank you so much, Mr. Ari Wahyudi. Thank you for all the speakers. Please give up. Thank you once again for such an inspiring and enlightening session on our third panel session for today's morning. And for now, I would like to invite Dr. Gratianus Prika to give our the token of appreciation to our moderator and also our speakers. Yeah, speakers. Yeah, first for Professor Yeti, and also please, we need help from our photograph. And the second is for Professor Jiang Liu. Last but not least, for our moderator, and now please step forward for photo sessions together. Satu, dua, tiga. Baik, 1, 2, 3. Baik, terima kasih. Thank you so much for all the speakers and also the moderators. And with that, conclude our third plenary session. Once again, thank you for all the speakers and also the moderator. Thank you, Prof. And now we move forward to our fourth plenary sessions on today's morning. Our fourth plenary session on democracy and global governance. And with this session, will be moderated by Jarod Dimas Andaru, SHMH. Dari sini. Oh yeah, please welcome PhD, our PhD candidate actually. Yeah, please welcome Jarod Dimas Andaru. Jarod Dimas Andaru is our lecturer at the Department of Economic and Technology of Law, Faculty of Law, Universitas Indonesia. Since 2022, He's also the secretary of the Center for Health Law and Policy Studies, and now active member of several professional organizations, including the World Association for Medical Law and the Indonesian Health Law Society. Please welcome, and the stage is yours.
Check. All right. Good morning, everyone. Good morning. Okay, thank you so much for the introduction of myself, the outstanding MC. My name is Dimas Ahmad Andaru. First of all, I would like to say good morning, honorable professors, guests, and esteemed delegates. Welcome to the fourth plenary session of 7 icLave. Last but not least, this is the fourth sessions, and we have 3 presenters. Are we ready to reveal the speakers for the 4 sessions? Yes? Okay. All right. So in this 4 plenary sessions, okay, thank you so much. It's not working. It's not working. Yeah, it's not working. Can the technical team help me, please? Okay. Yeah. For these 4 plenary sessions, we will explore more regarding how the disruption in legal and governance and how we see the concept of sustainability, development, and democracy in health and also governance. So, can we start the? Not yet? Okay. So let's us just welcome, first of all, Professor Veronica Taylor from the Australian National University. Please give applause to her. Okay. Welcome. Please sit down. She is a professor in the Australian National University. How are you, professors? Thank you so much. Second, we have Valentina Castagnari from the Georgetown Law and O'Neill Institute. Please welcome Valentina Castagnari. All right, and the third one, last but not least, we have Professor Dr. Satya Arinanto from the Faculty of Law. It will be... Oh, he is still on the way. Okay, just wait for him. But without further ado, let's continue to our sessions. We have Professor Veronica and also Valentina here. Welcome. This is your second day of icLave. I hope that you enjoy and already hear a lot of a fruitful discussion before, but we just started to dig deeper into the governance and also development and democracy. Okay, so first maybe we would like to give the session for Professor Veronica to deliver her materials regarding the governance. The time is yours. You have 20 minutes. Thank you.
Thanks so much. Good morning, everyone. It's great to be here on this second day of what has been a really interesting conversation. In the first 3 plenary sessions, we heard some really interesting comments about particular areas of policy and legislation. My presentation this morning builds on the kinds of comments that you've just heard from Prof. Yeti and from other analysis that we heard from speakers yesterday as well. What I'm really interested in is how we make legislation and the regulatory systems that sit under the legislation sustainable, how we make them healthy. So this is not about health law, it's about healthy legislation. Yeah, let's see how we go. So one question that we might want to think about is what kind of law and regulation does an advanced economy really need? And we heard from Prof. Yeti and from others that there are many legislative reforms underway in Indonesia at the moment. That's a good thing. But what kind and quality of legislation would we need for an advanced economy? When, as legal scholars, when we think about legislation, we tend to think about it as being at the centre of the legal system. So we think, first of all, here is legislation, then sitting underneath it is regulation, and then maybe off to the side are some court decisions. So this is how we think about our legal system. What the legal system actually looks like is that legislation is a fairly minor part of the system. The regulation is much bigger than legislation. Another way of saying this is that legislation is a kind of regulation. By regulation we mean not just rules, but any kind of design or system that changes people's behaviour, and that is designed to change people's behaviour. That's a longer conversation, but the point here is that legislation occupies a smaller place in the system than we typically think that it does. And in fact, if we really zoom out, what we would say is that legislation and court decisions are a type of regulation. Regulation is much bigger, but sitting behind regulation is politics, social context, and the economy. And so the argument here is you can't really talk about legislation unless you also talk about the politics that created it, the social conditions that it's trying to change, and the economic impact that it's going to have. Good morning, Prof. What's really new for Indonesia is something that Professor Farah talked about in the first session yesterday, which is the Brussels effect. So, as you know well, Indonesia is planning to become a member of the OECD. The OECD is located in Paris, not Brussels, but the OECD is a multilateral organisation that is dominated by the EU. So the rules of that club are largely shaped by European interests. To become a member of the OECD means to accept new standards for how to make law and how to create regulatory systems. So today I just want to draw attention to this and talk about some of the challenges that will create for Indonesia, but also some of the possibilities for us as legal scholars. So part of the OECD accession agreement is a big book, and in the book is all the homework for Indonesia. And the homework is set by the different committees within the OECD. One of those committees is the Regulatory Policy Committee. I've been working with the Regulatory Policy Committee now for a couple of years, and we'll be meeting again in November to talk about these topics. But the Regulatory Policy Committee is asking Indonesia, first of all, to show how we're going to create high quality law and regulation that is fit for purpose. Fit for purpose means not too much. So it means thinking about whether you really need to solve a problem with a new legal rule or whether there's another way to solve that economic or social problem. The second thing that is going to be emphasised a lot is the need to introduce regulatory impact assessment. So this is about the design of legislation. When you're designing the legislation, thinking hard about what is the purpose and what will be the likely effect, and the effect on who, which communities, which regions, which economic sectors. Part of regulatory impact assessment also includes thinking about whether you actually need new law or not. So it requires you to first of all ask, what is the problem we're trying to solve? And is there an alternative way of solving the problem that doesn't require more regulation? This is pretty new for Indonesia, because I think in Indonesia, when we're thinking about a problem, our first instinct is let's make a new rule, and then let's make that rule very, very specific, very, very detailed, new regulation for a new problem. And the regulatory impact assessment process says, whoa, hold on, stop. Just let's wait and think really carefully about this. Maybe the rules are not the problem. Maybe the people are the problem, or the processes. So let's think about those instead. The ideas in this homework, this long list of things that Indonesia will be required to do differently, comes from earlier thinking, which is summarised as better regulation, sometimes called the Better Regulation Agenda. And this is a body of economic work that came out of the UK, Europe and Australia in the early 2000s. And essentially it's an economic approach to law. So it's saying, yeah, law and regulation are justified if the changes can be created with minimum net cost or maximum net benefit to society. But you have to show the cost, you have to show the benefit, and you have to measure it in order to really be persuasive about the need for a new rule. So essentially the better regulation approach is economic, but in recent years, since this is now quite an old approach, a lot of new factors have been added into it, including human rights, including social well-being, including concern for the environment and climate change. So it's not an old-fashioned economic analysis anymore. Economics is the basis of it, but it has a whole lot of other important policy factors added in as well. The most up-to-date concept that we are using to think about law and regulation now is what we call regulatory stewardship. This was an idea that was first developed in New Zealand back in the early 2000s. And from 2013, New Zealand actually made this a legal obligation for all civil servants. And last year in Australia, we also made this a legal obligation for all our civil servants. What does it mean? It means that the civil servant's obligation is to think about law and regulation as a system. So not a single piece of law or a rule, but a system that has to fit together and fit together well. The second idea in regulatory stewardship is that regulation and law is an asset. It has value. It's creating public value, but in order to increase the value of the asset, you have to keep maintaining and improving the asset. And you have to do that with collaboration, not just from government, but also from stakeholders. Stakeholders here means communities, citizens, civil society, corporations, and sometimes international partners. And maintaining regulation as an asset means keeping it up to date. So you have to go back and revise your laws much, much, much more frequently than has been the case historically in Australia, in the US, in Indonesia. I've just gone one too far here, so I want to go backwards, but I'm not quite sure. Great job. Super. So when we say we're maintaining a system, it means that every law lives within its own life cycle. So we start off by doing the preparation, then we adopt the law, then we implement it, then we apply it, but at each stage we're getting feedback from the stakeholders and we're monitoring and checking the data. So once the law is put into operation, we don't stop there. We go back a year later and we check, how are things going? Is everybody happy? Is this working? Is the law actually meeting its objectives? Have we created some kind of problem that we didn't intend? If we did, then we need to do more revisions. And by more revisions, I don't mean an omnibus law. That's not the style that we recommend for doing the revisions. What we mean is a regular kind of health check for major legislation based on data, based on the voices from stakeholders, that then leads us to do regular updates, not revisions to the law every 10 years or 20 years or 30 years. Why do we care about this? Well, the health of legislation is actually an aspect of rule of law. So most citizens encounter law through administrative processes, through getting their identification or their status or their welfare payments. So I would argue that citizens are entitled to well-designed regulatory systems. It's not just a gift from government or a nice thing to have, it's actually an element of rule of law and something that in time will be recognised as a citizen's right. If we did a quick health check on Indonesian legislation at the moment, the results are not great. There are lots of aspects of the way that we make law in Indonesia and implement it that really don't meet global standards. So there's quite a lot of work to do. And in particular, quite a lot of work to do on consulting citizens and consulting stakeholders about what the changes should be and how the changes should happen. But the good news, the other thing that we are going to need in Indonesia is actually more legislation. So I noticed that the 2026 Priority Legislation Program proudly announces that there are 67 bills under consideration for 2026. How many bills does the Australian Parliament pass each year? Indonesia's going to pass 67. Australia will pass more than 300. So what this indicates to me is that an economy the size of Indonesia needs not only better quality legislation, but actually more frequent legislative updates, which means more legislation through the Parliament. 67 is good, but it's probably not the right number for an economy that really has the ambition to be fully developed. And my last point is, okay, so this is kind of a tough message, but there's some good news as well. The good news is that for legal scholars, as this regulatory reform work increases, there will be a lot more interesting opportunities to do research. Many, many new topics and many, many new areas that we can really work on and work on in a new style. Some of it requires collaborative research with economists and social scientists, but that's also a good thing because it will make Indonesian legal scholarship more prominent. And that would be a good thing for everyone. Thank you.
Well, that's very thought-provoking presentations. You were opening with the statement of a challenging or a problem regarding how we need to adapt our governance and our lawmaking, and you mentioned that we need healthier regulations. All right, talking about how we made law, how we legislate law, and also how does governance and also health, and also the health of the regulations are done here in Indonesia. Maybe I would like to welcome first Professor Satya. Welcome. Yeah. Oh, yeah. All right. Yeah. Okay. Yeah. So Professor Satya is the professor of human rights and good governance in Faculty of Law. Maybe he will deliver regarding how human rights and good governance in Indonesia. The time is yours, Prof.
Yeah. Okay, thank you very much. My presentation today is on democracy and global governance. Yeah. Okay, next. This is a short description about the structure of my presentation. Yeah. First, in the introduction, and then the theoretical foundation, democracy as a normative idea, and then the next is on the governance beyond the state, and then the next part I will describe about the democratic deficit in global institutions, yeah, like the United Nations, etc. And then on the democratic deficit in global institution, about the Bretton Woods institution, and then on the European Union. Okay. Next, okay, thank you very much. On pathways toward democratic global governance, especially on the global civil society, and then the next on the same heading on cosmopolitan democracy, and then also on global civil society, and then challenges and critiques and conclusion. But I will try to make very short because time is limited. Okay, let's. Okay, this is the introduction part. That we know that democracy and governance have traditionally been understood in the context of nation states, where the people exercise sovereignty through representative institution. Yeah. However, globalization has transformed this landscape. Decision-making power increasingly lies within transnational institutions, such as the United Nations, the World Trade Organizations, the International Monetary Fund, and regional blocs, yeah, like the European Union. The shift raises a critical questions. How can democratic legitimacy be maintained in a system where authority transcends national boundaries? Okay, next. Democracy, as its core, yeah, rests on principle of popular sovereignty, accountability, and participation. It presupposes that those affected by collective decision should have a voice in making them. In the national context, yeah, this principle is operationalized through elections, the rule of law, and the separation of powers. However, global governance lacks of a unified demos, yeah, for global people with shared institution or identity. This presents a democratic deficit where decisions with global impacts are made by actors who are not directly accountable to the people they affect. Global governance here refers to the sum of laws, norms, institutions, and practices that shape how global affairs are managed. Unlike global management, which implies centralized authority, global governance is decentralized and multi-actor, involving states, international organizations, corporations, and civil society. I quoted scholars such as James Personnel and David L., which argue that the diffusion of authority challenges traditional notions of sovereignty and demands new form of legitimacy. Next. Now we will talk about something about the United Nations here. The United Nations represents the most comprehensive platform for global governance. Yet its democratic legitimacy is uneven. The UN General Assembly operates on the principle of sovereign equality, but the Security Council grants disproportionate power to 5 permanent members. This imbalance reflects post-World War II geopolitics rather than democratic equality, raising persistent concern about fairness and representation. As we know, the International Monetary Fund and also World Bank are often criticized for their voting structures, which privilege wealthier nations. Conditionally policies have, at times, undermined domestic democratic decision-making in developing countries, as economic reforms are dictated by external democratic agencies rather than by elected governments. Now on the European Union, which provides an instructive case. It combines supranational decision-making with representative and participatory mechanism such as the European Parliament. Yet the European Union also faces accusation of being a technocracy, where decisions are driven by bureaucratic elites rather than citizens. So the EU struggle illustrates the difficulty of balancing efficiency and democratic accountability in multi-level governance. The rise of non-governmental organizations or NGOs, transitional advocacy networks, and digital activism has expanded the democratic space beyond formal institutions. These actors play a key role in agenda setting, norm diffusion, and holding international bodies accountable. Movements like Fridays for Future, for example, demonstrate how global publics can mobilize across borders to influence decision makers. Political theories, I quoted such David Feld and Daniel Achibugi, advocates for cosmopolitan democracy, which envision democratic participation at multiple levels, from local, national, and global. They propose reform such as a world parliament, stronger accountability mechanism for global institutions, and expanded role for civil society in international decision making. And now we are facing the digital democracy era. As we know, the technological advancement offer new possibilities for participatory governance. Online consultation, open data initiatives, and digital referenda could enhance global accountability. However, digital divides and cybersecurity risks I glad that democratization through technology is not a panacea. Yeah. So, despite this proposal, I will look some challenges and critics here. That global democracy faces structural and conceptual obstacles. The first is the lack of global demos. Yeah. That cultural, linguistic, and political diversity complicate the formation of a united global citizenry. Second issue, on the state sovereignty, many governments resist ceding authority to supranational bodies, viewing it as a threat to national autonomy. Next, the third one, that the issues on the power asymmetry, yeah, that global institutions often reflect the interests of powerful states or corporate actors rather than the global majority. And the last one is on the implementation gap. Yeah, even when global democratic norms are articulated, enforcement remain weak. So now I come to the conclusion that democracy and global governance are deeply intertwined, yet remain in tension. While democratic legitimacy is essential for the moral and political sustainability of global institutions, existing structures are largely intergovernmental rather than democratic. Achieving global democracy requires both institutional reform and a safe and political consciousness, yeah, toward recognizing that global problem demand global participation. In an era defined by transitional challenges, yeah, we know climate change, yeah, one of the issues in this conference, pandemics, inequality, and digital governance. The pursuit of democratic global governance is not an utopian ideal, but a practical necessity. Okay, this is a short presentation from me. Thank you very much for your attention.
Please give applause to Prof. Satya. Thank you so much, professors. Yeah. Right now, we already have a really good point from Professor Satya, that he mentioned that we are right now facing a globalization challenge and also transnational challenge in our regulation and governance. Now, before we moving forward to Valentina, we would like to explore more on how healthy regulatory and governance affect the real human health. Okay. Okay. Maybe I will give the floor to Valentina, please.
Thank you very much, and thank you for the invitation. I'm really happy to be here for the opportunity. It has been a great 2 days, so very pleased with everything we've learned and we've discussed so far. And I think my presentation comes at a really good time because both professors before me touched upon a lot of issues that I will be discussing today. This is not my presentation, Jared. But I can.
Okay. Wait. Can you change the presentations? This is the panel presentations.
In the meantime, I will give a brief introduction. I was saying I think my presentation will dialogue very nicely with what has been said before. I will speak about the need to regulate private actors, in particular, to enhance democracy, human rights, and sustainability. And I think both panelists before me have touched upon a few issues that will be very relevant for when I do my presentation. Professor Veronica was talking about regulation and the need to have good regulation. I will be touching upon some of those issues. And also Professor Arinato speaking about democracy, power asymmetry, and the need to also find a way to build participation in a really robust system in which people that are affected by their regulation really take a part in the regulatory systems and the outcomes of those regulations. So I think that's going to be very aligned with what I will describe, but I will be speaking about maybe giving it a little bit more life because I will be speaking about a specific case study around a health issue that is non-communicable disease prevention, and I will tell you a little bit about that in case you're not familiar with the topic, and bringing an example from Latin America, from Argentina, my own country, to think of good regulation and how we can move forward. I can give I will also give since I have extra minutes, a brief introduction to who I am. I come from the O'Neill Institute of National and Global Health Law, that is a think tank housed at Georgetown University in Washington, D.C. I am from Argentina, but we were a lot of international lawyers working there. And as part of that initiative, we've founded around 5 years ago the Global Center for Legal Innovation on Food Environments, where we do a lot of our work trying to promote healthier diets and prevent non-communicable diseases. So I think with that, if my presentation is up, I can get started. Okay. I'll wait 2 minutes. I don't know.
Yeah, apologize.
Keep it with
Yeah.
Okay, this is the right one. Thank you. Amazing. Okay, so as I was saying, today I will focus and I will speak about power. And I think, as I was saying, it's already been mentioned. And I would like to challenge the legitimacy of some of the power dynamics that we're used to. I will show how power unchecked has negative effects for human rights, for sustainability, but also for democracy. And I will argue that robust regulation, in line with what Professor Taylor was saying before, is a means to strengthen human rights and health governance, and also to strengthen democracy. And I will use non-communicable disease prevention as a case study with my own country, Argentina. So before I started, I wanted to give some clarity around what I thought, how I conceive democracy, but I think it's not necessary because we've already had a great presentation around that. But basically, democracy is not just about holding elections, but rather it's a process that, of course, requires elections, but also is based on principles of participation, transparency, accountability, rule of law, that at the end of the day lead to better outcomes in terms of rights realizations, justice, and equality. In turn, this also legitimizes the whole process and enhances the democratic process. So going into the specifics of my case study, I will speak about non-communicable diseases as an industrial epidemic. Really trying to showcase how power dynamics are very important for this specific health issue. So non-communicable diseases, for you who may not be too familiar with them, are diseases that have a slow progression and long duration. And they're usually described as in opposition to infectious diseases, which are diseases that are transmitted from person to person, for example, COVID. And the idea being that non-communicable diseases are not transmitted in principle, and I will explain in a minute, from one person to the next. So basically, the main non-communicable diseases are cardiovascular disease, chronic respiratory disease, cancer, and diabetes. This is a very important health issue because it's really the #1 cause of death and disability in the world. non-communicable diseases account for 74% of deaths globally. That's over 41 million people. And something very important is that 85% of those deaths occur in low and middle income countries. So really the burden of disease is not equitably distributed in the world, but rather it's it has a higher impact on low and middle income countries. In this context, something important also to note is that non-communicable diseases have been rising very rapidly everywhere in the world, but particularly in lower and middle income countries. That is the green line is the world and the orange line is developing countries. So you see that really the rise of non-communicable diseases is triggered by low and middle income countries in the world. So I said I will discuss this from a power perspective and thinking of corporations, and really this has been called an industrial epidemic. I said that non-communicable diseases were not transmittable from person to person, but increasingly we've come to realize that the vectors of disease, the way the mosquito is a vector for malaria, corporations are the vectors for some of these non-communicable diseases. And why? Because around 2/3 of the health of all non-communicable diseases are attributable to what are called modifiable risk factors, including consumption of tobacco, alcohol, and unhealthy foods that are really manufactured and aggressively marketed by powerful corporations, mostly headquartered also in the global north. So what we see is that a lot of this disease is preventable, and that is where us lawyers come into place, because there's a lot of opportunity to build regulation that can create environments that are healthier and that really promote conditions in which people can make healthy choices. Something very important is to understand that this is not just an issue of individual blame. It's not people just choosing to live more unhealthy lives. That would be hard because it would have to be a coordinated worldwide intention to do that. But rather it's corporations that are driving all of these behaviors very actively and aggressively, and they have thus received the name of commercial determinants of health. And this is something that the World Health Organization even has accepted in recent years. So a little bit of how corporations drive this disease. On the one hand, they produce and then aggressively promote, as I've been saying, harmful products. So if we see the first picture, the red one there is Lucky Strike's advertising from a few years ago already, fortunately. But basically, what we see in the tobacco industry is tobacco bringing physicians to the table and to their advertising, saying, for example, that tobacco was not harmful, that tobacco, the Lucky Strikes in particular, were less irritating than than other brands because they were toasted. When there was zero evidence of this, and the tobacco companies, by the time that these ads were coming, already knew very well that tobacco was addictive, that tobacco was harmful, and that they shouldn't be saying these things. So very intentionally lying, as we know now from a lot of industry documents that have been disclosed. But we see that with other industries as well, right? And so they build around this idea of popularity, of what making their products desirable. We see soda there, also a very harmful product that is aggressively marketed with a popular singer there, or through sponsorship in sports events. So this really finds a way to promote these products in a way that then people are not really autonomously making choices, but rather operating on their assumptions that these products are not bad, that they're good, or that they don't have enough information to understand what this means, and they're tailored in a way that are desirable from a social perspective. And another issue that is very important is how these corporations operate in the democratic process, and this is maybe one that is more closely or more easily identifiable with the topic of today. But basically, these corporations are very powerful. They have a lot of money and influence. And what they do, and we have a lot of documentation on this, is they interfere in policy-making processes. They try to deflect attention to their products being harmful. They deny the harmfulness, as we saw with the tobacco ads, but it keeps happening with other topics as well. And they really obstruct evidence-informed solutions, particularly regulation. when to be able to keep their products in the market and avoid getting any regulation that can hamper their interest, even if it's in the interest of health. So this, of course, undermines the democratic process. We see a lot of even intimidation and corruption, and also the use of litigation or the threat of litigation to obstruct a lot of these processes. And just to bring it home, the example of tobacco in Indonesia, we see Indonesia has one of the top interference on the top of the tobacco interference index repeatedly. So this is news from a few years ago, I think. And so with that tobacco interference, we see that we see the results in health, right? We see that smoking prevalence is still high, and it hasn't really decreased since the 1990s, and particularly affecting people in situations of vulnerability, such as poor people. One of the highest prevalences in the world, the only Asian country that is not part of the Framework Convention on Tobacco Control, and a lot of industry tactics really trying to obstruct any of these policies. So what we see with this is that when public interest conflicts with the public good, there is a power imbalance, and public interest oftentimes ends up winning because they have more power, money, and influence at the end of the day. So one of the ways in which we can think of leveling that playing field is building robust regulation. And what does this mean? Is regulation that really prioritizes and mainstreams human rights realization over profit maximization. So not to say that these companies don't have to operate, but rather that they have to do so within rules that make human rights a priority. Creating rules and limits of industry engagement in policymaking, including conflict of interest rules, but also others. And it really institutionalizing transparent, participatory policymaking processes to check power and to foster accountability processes. So in that way, regulation can not only enhance outcomes, but also be a good way to make democratic processes more robust. I want to check my time. Okay. So for the case study that I had for today was Argentina's healthy food law, and I will go briefly through this. But basically, Argentina adopted a healthy food law in 2021, and it's a really comprehensive policy package trying to really address, to really discourage the consumption of unhealthy foods. That includes front of package labeling, which are those seals that we see there that basically warn consumers if the product is high in sugar, is high in salt, or is high in fats. So trying to make information really visible and accessible and easy to use for consumers. Products that have these seals cannot be marketed to children, so no cartoons or any of those kinds of strategies. They cannot be sold in schools, and there's also rules for public procurement. So really, at the moment, Argentina is the top standard for these kinds of regulation in the world. And something that I would want to flag is that it has a very robust rights-based framing. So as you will see with some examples, both in the media communications and in the legal text as well, the right to health, the right to information really at the forefront of all the process. And why am I bringing this as an example? Because this is a really good example of how democracy worked in action. The law in Argentina really was very much appropriated by people. So civil society organizations were very active, were promoting the adoption of the law, were pushing for higher standards in terms of all of the design of the different components of the law. And there was a lot of mobilization and pushing Congress to really pass this law according to the best standards. So there was a lot of industry interference, but this also helped a lot to bring that down. There was consultation within the region, with other experts, with international organizations. So the process was really valuable. And it really helped not only bring about the top standards, but also legitimize and really have people appropriate the whole law. A few years later, 2024, this democracy meets corporate power. There were some regulatory changes. We now have a very corporate-friendly government, and they introduced some regulations that really watered down the standards of the law that had been adopted. And this is the opposite of what I was discussing a minute ago. There was industry interference, but also lack of transparency. No one really understands what the evidence is around or to support any of these regulatory changes. There was no opportunity for participation. And at the end of the day, what we got is weaker standards and the erosion of the legitimacy of the law, because people now don't understand whether they don't feel that the regulation really reflects the best for what's best for health. There's some legal challenges underway, but we'll see what happens. So just to conclude, I think this is a good example of how rights-based, robust, participatory regulations can address power imbalances and really enhance democracy and lead to better outcomes that then also help the democratic process. And some considerations how to do this. It's important to make rights-based objectives explicit, so that was that's very relevant to make sure that public interest is always prioritized over profit maximization when they come in conflict. Create safeguards for evidence-informed policy making, so best available evidence free of conflict of interest should be what informs policy making rather than biased studies that we know industry brings to the table very often. Disclose and manage conflict of interest to foster transparency, institutionalize civil society participation in decision making, and monitor implementation to foster accountability, because as we see with the Argentina case, it's not only about having a good law, but also, as Professor Taylor was saying, making sure that the standards and the real application work in the long run. So.
Okay, thank you so much, Valentina. Yeah, her presentation about food law in Argentina really give us a pictures regarding how regulations and also governance, healthy regulations, give a meaningful or actually promotes rights-based regulation and very, very powerful tools to govern and to navigate a challenge of globalization and also transnationalisms. Okay, so the floor right now open for question and answer sessions. Maybe we can explore about health, also the other aspects such as environment and also the Anthropocene aspect that already been discussed on the first plenary. So we have 3, okay? Yeah, first please, there. Please, you can introduce your name first and state your questions.
Thank you. My name is Raudina. I'm from Untak, Semarang. Thank you very much to all distinguished speakers, Mrs. Valentina Castagnari, Professor Veronica, and Professor Satya Arinanto for your insightful presentation. I really appreciate how today's discussion connect the idea of regulatory governance, democratic accountability, and human rights. My question is, this is simple for me. Given that robust regulations serve as a democratic safeguard by balancing public good and private interests, how can government in developing democracies institutionalize transparent and participatory regulatory process without being captured by powerful industries or political interests? Thank you.
Okay, thank you so much. The second questions?
Okay, my name is Faik. I'm from Universitas Diponegoro. Thank you for the presentations. They were very insightful. I had a question specifically for Professor Veronica and maybe also Professor Satya as well. As we know, there is currently an issue with a sort of a rightward swing to politics in general. So for example, I'm taking the example of the case of the wolves in Europe. As we know, the EU Commission President, Ursula von der Leyen, her pony was killed by a wolf. And what happened next was that she tried to reverse the conservation laws around wolves. She tried to degrade the laws, and as of September 2025, that initiative passed. So I was wondering about Prof. Veronica, emphasized the importance of constantly updating laws, of laws being responsive to the electorate, and Prof. Satya also emphasized how the EU has a democratic deficit, especially when it's controlled by these bureaucratic elites. So, what mechanism could we install to prevent these, these sudden rightward shifts where the parliament is captured by a specific electorate, which then tries to roll back the previous attempts to actually institute democratic governance within that institution, for example. Thank you.
Okay.
Could I have one more question?
One more question?
Okay.
Is it the same or?
It's related to the last presentation about the regulatory capture of corporate governance. Sorry, there is current research about, for example, formula milk. Formula milk, how that's in Indonesia, especially, that's seen as the healthier alternative to breast milk.
Okay.
And what sort of approach did Argentina also face this? What sort of approach was attempted, and what could be done with this? Thank you. That's all.
Okay. That's all. Okay. Thank you so much for your questions, Mr. Farid. Now, last question coming from person. Yeah, you can ask question from there. Please be seated.
Okay. Thanks very much. My name is Professor Yusuf Hedu from University of Nusa Lontar in Kupang, NTT. My question is related to Australian ladies and then Indonesian. You mentioned that your parliament produce more law, but unfortunately Indonesia have less. Can the Indonesian guy, Professor, why in Australia have produce more? Why Indonesia produce less in parliament? Thanks very much.
Okay, thank you so much for the quick and good questions. All right, now we have 3 questions, professors and distinguished speakers. First, coming from the lady from UNTAC about robust regulations, balancing public goods, and also the second question from Farid from UNIT regarding the importance of managing SIFT. This is quite a challenge, including question about the formula milk. Okay, and the third questions from Prof. Hanuk from Kupang regarding the parliament. Okay, maybe we can also discuss who want to comment first. Okay, sure.
Okay.
Yes.
Thank you for those questions. So for the first question, how to really institutionalize some of these mechanisms, there's a lot of ways in which you can think of. I think one very important piece is making sure that participation of civil society is a requirement. And I think it also dialogues with the OECD standards a lot, because when there's civil society participation, there's usually more transparency and there's a better chance for accountability. This is not, of course, the silver bullet, but it's one way in which you can try to foster this accountability. And on the other hand, also having better rules for how industry is participating as well. So it doesn't necessarily mean that industry has to be off the table in all contexts. In some cases, it is. For example, the Framework Convention on Tobacco Control really establishes that tobacco companies should not be at the table if there's a tobacco issue being discussed. But there may also be rules, for example, in what stages of the process industry can participate, and also in what ways and in what terms. Those instances of participation should be transparent. There should be a way in which whatever is discussed in the meeting can be accessed by civil society or by the population in general. So really fostering that transparency and making sure that whenever there's an engagement with the government, particularly when There's in discussion, for example, foods around the products that companies are producing. So if the regulated company is at the table, there's mandatory disclosure of those conflicts of interest. So if they're participating, really putting it on the table that they have a vested interest, and so whatever comes from their participation that may be legitimate and needs to be considered in accordance with their interest as well. This is important when you think around evidence and even scientific evidence. Scientific evidence that it has conflicts of interest does not have the same value, or should not have the same value, that scientific evidence that does not have conflict of interest, that is expected to be more objective. And I didn't go into depth around that, but there's a lot of studies showing that when industry is financing different studies, that biases the results. So it's important that in the policymaking process you have stipulations that only evidence free of conflict of interest should be addressed in order to inform policymaking. These are just some examples. There's other ways to do it, but those are some that you could think of. Did I go to the second one? So for the second question around breast milk substitute, that is a very good example of corporate capture. And it's also very well documented how particularly Nestle was the one who really promoted this idea globally that breast milk substitutes were better than the formula milk was better than breast milk, which is scientifically, of course, inaccurate and false. But there was a very intentional campaign to do this, and it included everything from giving samples to doctors, paying doctors trips or other ways in which they would then promote their products, interfering in hospitals and really giving mothers the formula milk as soon as babies were born. So that is very well documented, and internationally there's a breast milk substitute code that has been adopted nationally by many countries. I think Argentina maybe is not the best example in this case, but it has adopted the breast milk substitute code and others as well. But there's a lot of implementation challenges, and particularly recently, I think it was 2021 or 2022, the WHO released a document where they monitored breast milk substitute marketing online, and really the digital environment was really reproducing everything that was clearly against the code and what the companies had been doing before in the non-digital environment. So I think there are good rules for that, but the implementation has been very challenging, particularly in places that are very hard to monitor, such as digital spaces.
Okay, it's getting interesting. We can see that there is how to balance the public and industrial interests, including, like, if we start from the facts that about the formula milk industry, and sometimes the government need to retain their industrial to go and develop the economic, but also hearing what the public needs. So maybe Prof. Satya first want to add regarding on that, how to balance, Prof, between the interests.
Yeah, I refer to my presentation on the theory from David Helder, how we build or create the cosmopolitan democracy. I think this is one of interesting thing to be studied in the future. Yeah, here cosmopolitan democracy, which envision democratic participation at multiple levels, from local, national, and global. Yeah, the proposed reforms such as World Parliament, stronger accountability mechanism for global institutions, and expanded rules for civil society and international decision making. I think that's one of the interesting idea, maybe not only focusing on the local issues or national issues. Yeah. Okay. Thank you very much.
Okay. Thank you so much, Prof. Satya. Maybe we would like to hear from Prof. Veronica. You mentioned before about making regulatory system that responsible and sustainable to the chains, and we also have a question here from the floor that it is hard to navigate or balancing shift and also balancing interest between company, between industry, between public interest. Including in Indonesia, we have a lot of public interest from different culture, different people. Yeah, that's how we do that.
Yeah, I think also the question that our colleague asked was also about how do we make sure that one powerful person is not the decision maker, whether it's Ursula von der Leyen who doesn't like wolves, or whether it's President Trump. When President Trump came to power, in the first month of his second term, he changed the regulation about showers because he was upset that the shower was not delivering enough water. It wasn't pleasant for him, so he changed the regulation on showers. And we have plenty of examples from Indonesia as well. The point that we're making about creating architecture for a robust regulatory system in Indonesia and in other economies is that the processes that you put in place make it more difficult for a single person to impose their will on the public. The processes that are really important are processes like public comment, and in countries where public comment is well established, first of all, there's plenty of time for public comment about any change to a rule. But secondly, the public comments are recorded and made available, so you can see who has commented and what they have said. If a corporation is commenting on a legislative change, then you can read their submission and you can see the way that they have manipulated data or told one side of the story. That gives you the opportunity to then write to politicians or write to regulators and highlight the fact that this submission is wrong. Quite often there'll be public hearings and there's an opportunity to say publicly that the information that's being provided is not adequate or is inaccurate. The other thing that's important is that the speeches made in Parliament about the changes, potential changes to a law are also public and very easy to find. So that creates an environment in which it's easier for individuals or civil society organisations to put some pressure on the political actors. That matters because any kind of legal reform or regulatory change is ultimately political. Regulation looks technical, but it's actually quite political. It's carried out in a political environment, and we can't pretend that that's not the case. So there's always going to be a balancing of interests, and it's not the case that the winner is always public health or the environment or children or poor people. Quite often the regulatory result is unfair or not optimal, but the challenge, particularly the challenge for us as legal scholars, is to bring the very best evidence and the most accurate information we have in that moment and push that into the debate. Because if we don't do that, we're simply leaving space for poor decisions that aren't evidence-based.
Okay, check. Thank you so much, Professor Veronica. Is there any you would like to add? I guess it's already clear. Yeah? Okay, do we still have time? No?
Sorry, I think
Yeah.
that I failed to answer the last question.
okay.
The last question was why only 67 laws for Indonesia and why 300 for Australia? Okay. The answer is actually the same as the answer to the last question. In countries like Australia where the legislative design process is a bit more developed, much of the work is done before the bill comes before Cabinet. So every new law generally requires a regulatory impact assessment. The Parliamentary Drafting Office will carefully look at the wording in the legislation. There's a lot of committee work to make sure that the legislation is consistent with other laws. And you remember that Prof. Yeti mentioned these problems in her last presentation, you know, inaccurate drafting and also failure to coordinate across legislation. So, and all of the public comment and consultation. So all of that work has been done in advance. So that means when the bills actually get to the Cabinet and are approved to go forward, they can go fast because the quality and the research and the public consultation has already been done. So everything is lined up and it goes through the Parliament pretty smoothly. Of course, there's only 12 months in a year, so there's a time limit to get all the legislation through. And our view at the moment is that actually 300 laws is not enough. If we consider all of the updates to existing legislation that also need to get through. So we're going to have to find a way to speed up without impacting or undermining the democratic process and the ability for people to review this. But the time to review is really before the bill comes to the Parliament, not afterwards or during.
Okay, so maybe to sum up today's meeting, I will not conclude the result. It's yours to conclude, but I want to read one point that we can sum up from this fourth panel regarding the disruption in legal and governance by rethinking the concept of sustainability, development, and democracy. There is points that being discussed that making regulatory system should be responsible and sustainable. How to make it sustainable and responsible is not only base the regulations by the interests of our peoples, but the interest from a lot of aspects, including public and also the industry. And a good regulation is keep ever-changing and also ever-balancing regulations that answer the needs of ever-changing world and ever-changing challenge of globalizations and also transnationalizations. Maybe that's all that I can sum up. Thank you so much. Again, please give a big applause to them. Yeah, and I return the agenda to the Master of Ceremony.
Thank you so much, our moderator, for leading us into this session, our fourth panel for today's session. And without further ado, I will also invite Bapak Dr. Choki Risda Ramadan to give the token of appreciation to our speakers and also our moderator. Please. The first one to Professor Satya Arinanto. Please give us our biggest applause. And the second for Professor Veronica. And the third for Valentina Castagnari. And also for our moderator, and I'm pleased to take a picture together here at the front of the stage, there. Oke, 1, 2, 3, 3, 2, 1. Okay, thank you very much, our photographer team. And also thank you very much for our distinguished speakers, panelists, and also for the moderator for leading us into this fourth plenary session. And with that concludes the morning session for the second day of the icLave Conference 2025. Now we will have a lunch break, which will be served at the back of the building, our Selasar new building. Just like yesterday, placement is exactly like that. And I will also remind to please take your personal belonging, because after the lunch break, we will continue the panel session according to the schedules and also room assignment that already provided to the website. Please kindly check. And now I have the important additional information, so I would like to please Bapak Zadi Takwa to inform.
Thank you, Mbak Anai. Good afternoon, everyone. Assalamualaikum warahmatullahi wabarakatuh. Okay, so I'm going to provide a important update for panel session because we have a limited numbers of people attending to the panel session. So we will conduct the panel session in auditorium in this room. All of the presenters will present the materials in auditorium. So after you eat for lunch at the back of this building, then please come back to this auditorium, and we will compartmentalize the session into 2 sessions in this auditorium, and each presenter will have the opportunity to speak for maximum 10 minutes, and then what else? I think that's all. And also, please, because we will conduct the panel session in auditorium, Pak Cecep, can you provide the email? So please, you send your materials to this email. So after you have sent the materials, then it will be easier for us to present in front of the stage. Pak Cecep, okay. In the meantime, can I just want the presenter to raise their hands as Saiful, who will present as Saiful? Okay. You will have 2 papers to present, or just 1 paper? 1 paper, okay. And then Ika Riswanti, 1 paper. Yudit Eva Meta, 1 paper, Bu. Suhaimi Abrahman, 1 paper. Yusuf Leonard Henuk, 2 papers, okay. Anita, 1 paper. And then Kristianto, 1 paper, Pak. And then Widati Wulandari, 1 paper, Ibu. And then that's all. I think that's. So, is there anyone in this room that I haven't called that will present? What is your name, sir? Andi Muhammad Aswin, okay. Andi Muhammad Aswin Anas, okay. Okay, this one, everyone, please send the materials to cecepurnama@ui.ac.id. Please make sure you send the materials to this email. If you have done so, please enjoy the lunch, and I will. Okay. And we will start this session right at 1 p.m. I hope you guys have finished eating the lunch and also have prayed, so on and so forth. I think that's all from me. I will give the mic to MC, Mbak Anai. Thank you.
Thank you so much, Bang Zadi, to provide us the new information that is very, very important. And I would like to highlight, so after our lunch break, back at this building, please come back to here for start the panel session in here. All of them. Okay, so without that, please enjoy the lunch and we'll see you around in the panel session. Thank you so much.